I know that you have been introduced to Justice Englander and Justice DeAngelo. I am Amy Blake. We are now going to hear the case of Town of Concord versus Rasmussen and others, docket 23P 310. You may proceed.
Gwen King on behalf of the defendants. May it please the court. The determination of whether or not a way is public has important consequences for private landowners, municipalities, land surveyors, and title examiners. The court has consistently held that there's a high bar for establishing a public way, but here, in holding that Estabrook Trail was both once public and remained public after the 1932 discontinuance, the land court committed 3 fundamental legal errors and deviated from that high bar, requiring reversal by this court. First, the first legal error is that the land court determined that a discontinuance under the 1924 Act to discontinue public ways resulted in a permanent public easement. In so holding, the land court ignored the plain language of the statute, which adjudicates the way private and warns the public against entering thereon.
Counsel, maybe we could find, that the language of our court in Coombs was purely dicta. Maybe. But what do we do with Nylander versus Potter, the footnote, which says, a legal discontinuance by town vote of a road as a public way is to be distinguished from a discontinuance of maintenance under Chapter 82, Section 32A.
Your Honor, let me start with Nylander and then I'll address Coombs. Nylander expressly in that dicta noted the 1983 version of the statute. Now, the 1983 version of the statute is entirely different, and as noted by this court in the Smith v. Marlborough case. But Coombs actually, the posture of Coombs illustrates how the 1983 Act was entirely different. The Coombs court was considering whether or not a town municipal body, the road commissioners, had authority to cease maintaining a county way. The posture of that question only existed because the 1983 Act took the power away from the county commissioners, who had the authority to discontinue ways pursuant to Chapter 82, Sections 1 through 4 and 32A. It removed it from their jurisdiction and left the 1983 version the limited power that remained with just the municipal select board or road commissioners of the town, a completely different authority and jurisdiction. Coombs illustrates the point that the 1983 version is completely different than the 1924 version. The 1924 version here adjudicated the way private. The only public body that could adjudicate the way private was the county commissioners, and they adjudicated this way private.
So at that time, they could not have brought it to town meeting?
When you say at that time, I'm assuming you mean from 1920.
1928, was it, whatever it was.
At the time of this discontinuance, there were two ways that this could, or actually multiple ways this way could have been discontinued. But to pursue a Section 21 discontinuance by a town meeting, you would have a completely different discontinuance. As noted by the Nylander court, and the question before the Nylander court.
Why would it have been a completely different discontinuance?
Because as noted by the Nylander court, Your Honor, a Section 21 discontinuance completely eliminates all rights over the way, including abutters' rights. That was the question that the Nylander court was speaking on.
I don't understand. Who owns the way if you get rid of the abutters' rights as well?
Well, according to Nylander, a Section 21 discontinuance, nobody owns the way. It reverts to the abutters to the center of the line.
Oh, okay. So the abutters own the way under Section 21.
Right, but there's no remaining private abutter easement rights. So there's no, if it's a
There's no easement rights.
Correct.
Yeah,
but
it's just owned.
Correct, but the distinction is important here because the way was adjudicated private, leaving intact abutters' easements rights over a private way. And that is why there were
Whoa. Slow down.
Sorry.
So you're saying the difference between a Section 21 discontinuance and a 32A prior to 87 discontinuance is Section 21 eliminates any easement rights at all, but a 32A leaves just the abutters with easement rights.
Correct.
Okay. In what context can you cite to me a situation where a town or a city gives up its rights to property without a vote at town meeting?
Well, in Chapter 82, Section 30, it can be appealed to the county commissioners who have the authority to discontinue the ways. In Chapter 82,
Slow down. So which section is that?
Section 30.
So that's a 21. If you don't discontinue under 21, you can appeal to the county commissioners under 30, and under 30, the county commissioners had the ability to take away the town's rights completely, right?
Correct.
Is there any other than Section 30?
Also, under Sections 1 through 4 of Section 82, if you read the language of the county commissioner's authority, they have authority over ways, both highways and ways from one point to another within a town. And that is significant because the
Authority over them, does that mean the town's ownership is taken away?
Yes, pursuant to the authority to discontinue and lay out ways, which is articulated in Chapter 82. And what's
Sections 1 through 4, I'm going to find that in 1 through 4?
Correct. Now, the reason that I want to keep coming back to the county commissioners is because their authority is over the right to travel. The common convenience was this way was no longer needed for common convenience and travel as adjudicated by the county commissioners. That is the same premise under which county commissioners can lay out a way and discontinue a way. That eliminates the public easement of travel. And as we note in our briefs, the public easement of travel is the only easement that the public has over a way. When that was eliminated by the discontinuance, what the 32A Act purposely did is it left a private way intact for the abutters to have a private way, which they could open or close at their own discretion, consistent with the common understanding of private way.
Where does it say that? Just because it uses the words private way?
Well, it adjudicates it private, but significantly, it doesn't award damages to landlocked owners like Section 21 would require. Now,
Okay, but so the answer to my question is the way that we're just not as facile with you as you are with this. We didn't live with this, we didn't try this. It's complicated, okay? And what we're talking about here is important. And so I'm really trying to understand when you say it's done under Section 32A prior to 1987, that it preserves the easement for the abutters, okay? The reason you say that is just the word private, right? Or the language that says that it changes the way to a private way.
well, I think the adjudication of it being private is indicative of that. The warning to the public against entering is indicative of that. But I actually think Nylander is indicative of that, because what Nylander determined, it overruled this court and the Superior Court in Nylander. And it determined that those courts had determined that there were abutters' access rights under a Section 21 discontinuance. But Nylander said, no, there are no remaining abutter access rights after a Section 21 discontinuance, and instead, it cited to the 1983 Section 32A, which again is not before the court, but the analysis of Nylander shows that there is a fundamental difference between a Section 21 discontinuance, which eradicates everyone's rights over the way, and a Section 32A 1924 discontinuance, which leaves intact abutters' rights. Now, in further support of this, our brief from pages 60 to 62 cite the discontinuance docs in this case. Those discontinuance documents illustrate the intent of all parties to have this way legally discontinued.
I'm going to ask your opposition this, which is the way the judge interpreted it, it made no sense to me that the abutters asked the town to make it a private way and they really wouldn't have gained anything under their theory. But is that relevant to our determination, the intent of the parties at the time the discontinuance was made?
It's entirely relevant, Your Honor, because the lower court determined that the word private way was somehow ambiguous in the statute. We disagree with that. The statute clearly says what it says.
Well,
but the intent...
That's not what Nylander says. That part of the statute didn't change. They still use the same language that was in effect in 1932. Respectfully,
Your Honor, they did not.
Tell me how it's different.
There's no adjudication that the way is private. There's no utilization of that language anywhere in the statute. They completely rewrote the statute, they eliminated the title, and no longer utilized discontinuance. And more
They
important,
rewrite it, they left the last sentence exactly the same.
well, this court held in Smith v. Marlboro that it was significantly rewritten. Now,
Oh, the last sentence is exactly the same. The sentence that you rely on heavily to say, look, they wouldn't put up a sign that says, warning, don't come in, if it didn't mean that it had been changed away from a public way, also is in the 1987 statute. So they didn't completely rewrite it. At least give me that.
I give you that, Your Honor, and I can see that the posting remained the same in the 1983 version. It subsequently changed significantly in the 2006 version. But what I would like to note, though, is that in terms of the concept that the town would have pursued this, as suggested by the land court, just to close the way to eliminate maintenance responsibilities, I want to refer the court to Chapter 84, Section 24, which is in the addendum at page 185. That is under the chapter regarding maintenance of ways, and that allowed a road commissioners or select board to independently close the way, post a warning, and relieve itself of liability and maintenance. That is not the section that was utilized by the road.
That was directed to the road commissioners of the town or of the county?
Of the town.
So in the history here with respect, is it 1932 when they went and asked for the discontinuance?
Correct.
Who provoked that?
So that's telling, Your Honor. The landowners here petitioned the road commissioners initially to say, look, we have to close this way. Hasn't been maintained in any recent history. It's a fire hazard, and there's just occasional picnickers on it. You see from the records that we've attached to the addendum that the road commissioners considered it.
Tell me why the intent is relevant here. Because there may have been a misunderstanding by both the town board, frankly, and the abutters as to what that statute meant at that time, which Coombs, and again, I understand what you're saying about Nylander, that's not the way the SJC is interpreting it. So how do we factor in the intent?
Again, I do want to note that the SJC was interpreting a different statute, but for the intent, it's critical here when we consider what the legislature meant, how municipal bodies would have looked at it, and how private property owners would have looked at it.
Oh, I agree the legislative intent might be relevant, but how is the intent of the abutters, and at that time the town board or whoever it was that voted, why is their intent relevant?
Because in this situation where the land court deemed it to be ambiguous, how it was utilized by private, public parties, both the municipality and the county commissioners, informs what the intent actually was. And I think to the North Andover amicus brief, the point about what the public would have understood about the public notice is a critical one. If you look at the record, the public notice for this discontinuance is in that record. There is nothing that would indicate to the public that this way would continue with a permanent public easement. And the suggestion that that would somehow be embedded in it is...
Why is that important? Why do we care? I mean, because the notice is not... why do we care?
We care about the public notice because that indicates in this adjudication of the county commissioners what was being done, what was asked, what the public could opine on, what the public could object to, what the abutters could have objected to. That there's no question here that everybody understood it to be private.
Isn't that just, it's a debate over what the word private means. And we've got case law upon case law that says that private doesn't mean private. Private could possibly mean, in fact, often means, that the public still has access, right? We got all kinds of case law that says that.
Respectfully, Your Honor, no. I think...
You don't have all kinds of case law that says that?
We have all kinds of case law that says that there could be different interpretations to the way private. But what the divergence of possible definitions does not create what the town suggests is only one reading of the statute. The context of the statute from...
Right, but so the way we got here was through the notice thing. And if the notice is talking about changing something from public to private under Section 32A, I don't think you would have nearly enough space to try to explain that that could mean a whole lot of different things. I mean, you're stuck with whatever the law is, and private could mean public, it turns out.
But perhaps your question actually illustrates why the legislature's silence on articulating, as the town said, that this would have been some public way in perpetuity is telling. They didn't indicate that. Contemporaneous case law, the Luigi case, shows that the word private at the time of 1924 meant private. Now, the cases that are relied on by the town illustrate that centuries ago.
Which case is that? Luigi?
It's the Luigi case. It's
Is it talking about the word private in Section 32A?
No, it's a 1923 case that came out several months before the passage of the 1924 Act, and it clearly says that a way is private means the public is not welcome onto it unless invited by the owner. And significantly, it says if the public is warned against entering, it's a private way.
Well,
That
just
shows-
a moment, counsel, because your time has expired. Do you have more questions?
Well, yeah, I had one,
Okay.
at least.
Please finish your answer, and then Justice Englander does have another question. I promise opposing counsel that you'll have additional time if it's needed, okay? Please continue.
Well, my question was about Coombs. I mean, what do we do with that language? That's from our court. Should we just ignore it? It says, and it's talking about construing 32A, and it says, thus eliminating the expense of the town's burden of maintenance while leaving unimpaired the public's right of access over the road. What do we do with that?
Well, I think actually the qualifying language to that, which just says a natural reading of it, perhaps illustrates to the court that that wasn't the question before the court. It clearly wasn't. The question was whether or not road commissioners could cease maintaining.
Oh, it's dicta.
It's
and we should
complete
ignore
dicta,
it.
and I suggest to the court the documentary evidence in this case regarding this discontinuance, North Andover and Franklin County's amicus brief, shows that the statute from 1924 to 1983 was construed differently. Its plain language was what municipal practitioners were looking to in determining whether or not they could discontinue the road. Now, I know my time is up, but I want to note that there are also significant issues as to whether the way was ever public prior to 1932. And if I may, I think it's very important that the court understand there is no layout for the southern portion of the trail. Now, the town contends that it should be able to establish prescription by a standard that is less than that articulated in Baluchian, Boxborough, and Sproul. However, it's important to note that the town in this case is subject to antiquated or ancient records because they discontinued the way in 1932. But more importantly, they also dismissed in this action any claim for prescriptive use over the trail from 1932 forward. So the fact that they're confined to ancient records in this case is of the town's own doing. And it does not relieve them.
I apologize,
No,
but it's such a complicated case.
Please do, Justice Englander.
How do we overcome the finding of the judge that the various prerequisites to prescription, public prescription, were met here? How do you overcome that? Is this he's clearly erroneous? Is that where we are? So I'm leaving aside the whole point about, we don't have a layout and, that
Understood.
whole argument. Just talk about public prescription. Is it a clear error argument?
It's twofold. There is a legal error here, and the legal error is that the land court said, and he said it on page 56 of his decision, use by line workers established prescriptive use which has not been rebutted by the private landowners. That is an error, and that is in direct contradiction to Sproul and Boxborough and Baluchian, which clearly hold that in establishing a public way by prescription over a private way, you must have direct evidence of adverse public use. And there is no presumption of adversity
So he
when
may
there
have
is.
erred by suggesting a presumption, but he did find direct evidence of public use, and he found it in two different timeframes.
But, Your Honor, that actually leads me to my second fundamental error, and that is that the type of evidence that was relied on by the land court does not meet the threshold requirements of Boxborough or Sproul. And what I mean in saying that is all of the uses identified by the land court, with the exception of the one maintenance record for the trail, only one maintenance record, all of the other uses are entirely consistent with the way having been private. Now, as the court has held time and time again, for good, sound public policy reasons, we don't want to force private landowners to gate private ways.
That's a clear error argument. That argument is the evidence he's relying on did not satisfy, I mean, it's hard to make that a legal argument. It sounds like a clear error argument.
But it would reduce the legal standard of direct evidence.
Okay.
And I will say also, in terms of whether or not there is a clear error, I will say that we suggest that the court do inspect some of those conclusions by the land court, particularly on pages 54 through 57 of its decision. And the land court's decision is premised on the following phrases. There
Counsel,
would
we're going
have
to have to leave it there. I'm sorry.
Okay.
Thank you.
Thank you, Your Honors.
So the town, if you need it, we will give you an extra 5 minutes and 6 seconds, but let's see how we do.
Good afternoon, Your Honors. Austin Anderson for the town of Concord. So as Justice Englander recognized, the question about the legal effect of the 1932 statute really turns on the meaning of the phrase private way. And the land court recognized that this was a central issue, and it devoted pages and pages to analyzing this when surveying the case law, talking about the use in early statutes.
If the judge's interpretation is right, based on Coombs and at least maybe Nylander, why in the world would the abutters at that time have asked to turn the road from a public way into a private way? They gained nothing under that interpretation. Before they did that, the town had to maintain and keep it clean, etc. Afterwards, you're saying now they don't have to keep it clean or do anything, but it's still their road. So why would the abutters have ever have asked the town to turn it into a private way?
So first of all, let's start, Justice D'Angelo, with what you suggested, which is that the abutters might have been mistaken about the legal effect of the statute.
And the town?
There's no indication that the town was mistaken about it. The town doesn't say we want this to be closed. The town says we want to get rid of the maintenance responsibilities, because we have the records from the road commissioner saying this is one of those public ways that's infrequently used. It's just used for logging, and it creates a lot of damage. The town has to expend a lot of money to keep it up. So it makes sense for the town to want to discontinue the maintenance.
You're right. How about the amicus brief? Because they're pointing out, I think, that this was done after that change in many other areas, again, thinking the abutters thought they were gaining something by the town changing it from a public way into a private way. It became the abutters' land. Why?
So we still have the fundamental problem that if there was a mistaken understanding by the abutters or even by some of the town officials, that doesn't change the meaning of the statute.
For 60 years. Because that seems to have been what was done for, give or take, now we're talking in decades, give or take a decade or so, that seems to have been the interpretation of people that petition towns to change ways from a public way to a private way.
So I don't think we have any evidence at all that that is the actual intention. We have records referring to discontinuance as a public way, and there's no dispute that what happened here was a discontinuance as a public way. This is not a public way anymore. It's not being maintained by the town. It's open. It's a private way that's open to the public, as Coombs recognized, as Nylander recognized. So I want to first contest that there's any evidence that that was the intent of the town. Or that was the effect.
Can I just stop you there for a moment? So, okay. The amicus brief is not evidence, and we don't know how prevalent the practice was. There was an effort to put in evidence about this, about Concord's own discontinuances, which the town objected to and which did not come in. Is that right?
Yes.
What does that offer of proof show with respect to the discontinuances that occurred under this statute in the town of Concord?
Respectfully, I think the land court was correct in finding it doesn't show anything.
That's not my question. I can go look at the offer of proof. I'm asking
Yes.
you, what's it going to show?
It's going to show that some of the roads that were discontinued under this statute later were built over or not treated as if they had a public way.
Okay,
Whether
so-
that's relevant depends on what the legal status of that road was the day before it was discontinued. Obviously, the 1932 discontinuance doesn't create any rights in the public. It preserves whatever rights exist before, but if there was no public access to that way before the discontinuance, there wouldn't be any after. We'd have to go through the same exercise we did with this road to just determine whether those other roads are relevant in the first place.
Which,
and then
by the way, I think helps your argument, your first part of the case, that it was a public way, because now I'm going to reverse what I said before. Why would the abutters have asked for it to become a private way if it already was a private way? So I agree with you on that part. But continue your thought as to the offer of proof somehow isn't relevant, because to me it is.
Even assuming the offer of proof shows that the abutting landowners and the town officials understood that this would have gotten rid of public access rights. All that is one small piece of evidence to weigh against everything else when deciding how to interpret the statute. There's one canon of statutory interpretation that the abutters cite to, saying we can look at how contemporary officials would have understood it. That's not conclusive. It doesn't outweigh everything that the land
And
court
your
looked
point,
at here.
your other point is really that it's just sort of like other acts evidence, right? It leads us down this collateral road of trying to figure out what actually were the circumstances with respect to each one of those particular, and that's what I assume that's the basis for the objection that was made, right?
Correct, Your Honor.
Yeah,
We would
okay.
have to go through all that, and it doesn't even get you that far, because even if we are able to determine they are relevant, all it says is, okay, now we have this one canon about contemporary interpretation weighing.
Is your sister right about, so I have a little bit of knowledge about trying these cases, and I always thought that if a town wants to give up its property rights, town meeting has to vote. Your sister says, no, it's not true. Clearly not true, because in other sections of Chapter 82, the county commissioners had the ability to take away the property rights of the town. Is she right about that? Section 30, I read that yesterday. She seems to be right about that.
So Section 30 provides a limited exception where a town vote has already happened. So the county is...
Yeah, town said no.
Right. The county is on notice that the town said no, and then it also provides additional safeguards for public rights that aren't available under Section 32A, including notice, surety, ascertainment of damages. So yes, Section 30 creates a small window for the county to take this action, notwithstanding the fact that town meeting disapproved. First of all, town meeting still has to be involved.
So there's one small window. So is it also true that sections 1 through 4 allow the county commissioners to take away town way rights from a town?
Only in conjunction with Section 30. It's the same process.
Is
But-
there any other area of the law with respect to town ways where a way can be given, where the property can be given up by the town without a vote at town meeting?
I don't believe so, Your Honor, no.
Case law actually suggests you need a vote at town meeting, right?
The SJC in Mahan v. Rockport said
Yeah.
the vote of the town is required. It has to be the town acting in its corporate capacity.
Because, there's this sort of odd circumstance to it that, like, if they're right, then the town not only is giving up its property through this process that doesn't involve a vote at town meeting, but they're giving it back to the abutters, right? The abutters are sort of having property dropped in their lap? Is that your understanding of what the position is of the other side?
Yes, and further than that, an additional reason that it's not a reasonable way to interpret the statute is who in the town is acting here. Section 32A, the 1924 statute, gives authority to the officials in town having charge of the way. That's the road commissioners. They are the ones with statutory authority over maintenance of the road. They don't control public access rights.
Well, or the board, right? Upon petition writing of the board or officers of the town having charge of the way. So your point is, look, given the or, the road commissioners could just give away town property.
Exactly. And that, not only does that conflict with what Your Honor is saying about town meetings' proper role, it would also render Section 30, which we were just talking about, superfluous. There's no reason that anybody would go through the trouble of a town meeting vote first if they could accomplish the exact same end by just going directly to the county. I do want to address.
Oh, I don't understand that. Section 30 allows them to do it if the town says no, right?
Correct, after they've gone to the town. But if Section 32A means what the abutters are arguing, you can do the same thing without going to the town first. So nobody's going to use Section 30.
You can reverse that argument. Maybe the town commissioners are going to vote no, so you take it to the whole town. You can do it either way pursuant to the statute. Under 30, you can go through town meeting, right? And under 32A, you can go to the board or officers.
So, Your Honor, the only reason I'm hesitating, I'm not sure if the road commissioners or the board has to be involved as a first step as the ones asking town meeting under Section 30. Regardless, it doesn't make sense to read the statute that way, given town meeting's proper role here. There are two possible meanings of this statute, especially given what we know about the ambiguity of the phrase private way. It doesn't make sense to adopt the one that is either renders Section 30 superfluous or just adopts this separate procedure for doing exactly the same thing. So I want to address Ms. King's argument that there is a difference between Section 21 discontinuance and the Section 32A discontinuance.
Before you do that, can I just ask you about the ramifications of the decision? Because the amicus brief suggests that there are a number of undesirable and unintended consequences from this decision that would flow to municipalities. You represent a municipality. Do any of the scenarios that they have laid out in their brief, do any of those have any concern for you?
No, Your Honor, for at least two reasons. The first of which is that if there is, as we said in our response, if there's any genuine concern about this, you can just discontinue the way under Section 21. It's commonly accepted practice to do that to a whole bunch of roads at the same time, whether or not you know their status, whether they were public or not. You do it out of an abundance of caution. That's the Rivers against Warwick case. I think it's also important to bear in mind that this decision doesn't change what the courts have said about the legal effect of Section 32A. It's consistent with Coombs. There are cases following Coombs saying exactly the same thing. The appeals court in Mayut v. Deuce, the land court in Stone v. Garcia.
Andover's just made a mistake. I can't remember if it's Andover or North Andover. They've just made a mistake. I mean, the way I read that amicus brief, there's property on a 32A discontinuance that's been built on.
Right.
So it's possible that North Andover meant to use Section 21 and instead use Section 32A. If they did that and they want to make sure there's no public access rights, they can fix that tomorrow with no problem. But these are hypothetical concerns, and the fact that we haven't seen these cases in the 36 years since Coombs came down means that it's not going to come up very often. This is a unique situation.
But that, I think, is at the nub of my question, which is if the decision stands as you want it to, is this just a one-off on this case, on these facts, on this particular area? Or is this going to upset the apple cart across the Commonwealth? That's what I'm trying to get a sense of.
There's no reason to think it's going to have any problematic effects. The ruling applies to the legal interpretation of the statute, so it applies to more than just this case. But the fact that this is the first time this is being directly litigated shows you the unique circumstances that have to combine in order to get to this point.
Couldn't it be that the reason why it hasn't been litigated is because the people that have property on these ways that they thought were made private, that was the end of it? They never thought they had to litigate it. But now towns could go in. You did it the reverse. You said the town could fix these problems by just doing this tomorrow. What if the town wants it the other way? What if the town wants the property and they say, oh, that wasn't a private way that you built your huge building on. That was just a private way for purposes of maintenance, but it's still a public way. We want it back. Then what?
Under the legal effect of the statute, the town would be able to say that. I think now we're
You
way
said
into...
would be able to say
Would be.
that. I just want to make sure I heard you. The town would be able to.
If the statute means what we say it means, then a discontinuance under 32A preserves public access rights.
Could there be adverse possession versus the town?
Well,
Prior to 19, whatever, when the statute changed, there would be adverse possession, right?
yes, and also it's not against the town. This is it's a private way open to public access. It's not land that belongs to the town. So I think even after that statute, you're not
I
trying
don't
to possess.
understand that at all.
Yeah, you're going to have to clarify that. It seems to
Way
me
belongs
it's
to the
public, it's
town.
the town.
It's a private way subject to public access. So this goes back to the three different kinds of private ways.
So your view of private way subject to public access is that there's just an easement in favor of the public, but the actual fee ownership is in the abutters to the way up to the center line?
Yes, I think that's a fair
Okay.
statement.
So, but there's still an easement in favor of the public.
Yes, so again, we're into a hypothetical case here. I think it's going to depend on the facts of what this, first of all, again, what the public's rights were before the discontinuance happened. Second, what's happened since. Whether any public easement has been extinguished.
I didn't even understand that until this moment. So your position as to a 32A discontinuance is not that the town owns the way in fee, but the public has an access easement over that, which has now reverted in terms of it. So if it's a public way, the town owns it, right?
Yes.
From Stonewall to Stonewall. Once they do a 32A discontinuance, your view is the town has given up the fee interest, but retains the easement.
So, Your Honor, this question wasn't litigated in this case. It's not.
No, which is why I'm asking the question, because, see, I was concerned about town meeting being the way that towns give up property, and now you're suggesting that maybe the way to think about this is actually the town did give up property, gave up the fee.
So it's not, our point about town meeting is not giving up property, it's giving up public rights. It's the access right of the public, the right of the public to use the way.
That's huge. If they own it in fee, they can decide that they're not going to use it as a way anymore and build a town building on it.
So I don't think there was a finding here.
Am I wrong about that? This is complicated stuff, and I don't want to be overbearing because I'm really trying to understand it.
So there was no evidence in this case, there's no finding about whether the town owned the land in fee prior to 1932. All the evidence says is it was established as a public way, either by a layout or by prescription, meaning the public had a right to access it.
So prescription doesn't give you the fee. Prescription just gives you the easement.
Correct. All that we have argued, all that you need to uphold the land court's decision is to find that the public had an easement for travel over the way in 1932 at the time it was discontinued, and then the effect of the statute does not extinguish that public right. So,
Thank you.
So I interrupted you when you were going to talk about Section 21, and you were over time, but as I said, I'm going to give you the same amount of time I gave opposing counsel. So you have about 3 more minutes, however you want to use it, but I can't promise that my friends here won't have more questions.
yeah, I appreciate that, Your Honor. I just wanted to respond to one point that Ms. King made about the difference between Section 21 and Section 32A. We all agree that there's a difference between them. They say the difference is 32A preserves private rights of the abutting landowners where 21 doesn't. Nothing in the statute says anything about abutters or abutters' rights. It's focused on the town, it's focused on maintenance. There's nothing to suggest that the reason they enacted the statute was to protect the abutting landowners. And of course that doesn't, well, first of all, it doesn't account for town meeting's role in extinguishing a public
Agree
easement.
there's a difference between the two?
Yes, absolutely.
What is it?
A discontinuance under the 1924 statute leaves public access rights intact. It's a private way.
Discontinuance under 21 discontinues public access rights.
Correct.
And so the property is where? The rights in that property are where?
Under Section 21,
Yeah.
they're in the abutting landowners. Nobody has any rights in that way anymore after Section
Easement itself
21.
is extinguished. It's no longer a way.
Correct. But under 32A, public rights are not extinguished. There's no reason to think that they were this statute was enacted to protect abutters' rights, and we don't see that in the 1983 version, too. We go into this in the brief.
Well, let's talk about that. So on Record Appendix 6, page 207 and 208. But on 207, we have the 32A statute that was in effect in 1924. And that uses the language, shall thereafter be a private way. Then we have the next page on 208, the statute that took effect in 1983. And there's no mention of private anymore. It's now explaining what public way means by prescription. I mean, by... So, doesn't that mean there was a change in the statute specifically? You're saying it was just interpreting it to clarify, which I don't know whether that helps or hurts you, but it seems to be a change in the statute.
The only substantive changes to the the only changes to the procedure by which the way is discontinued. The way private way would have been understood in 1924 when the statute was enacted included public access rights. This is the SJC opinion of the justices from 1943. It says there are three different ways, three different meanings of private way. The first two include public access, the third one does not. So the change in 1983, this is why the court looked at the legislative history, because the language itself can't answer this question if we don't know what private way means just based on those two words. The court looked at the legislative history and said nobody thought or said anything about this creating a major substantive change to how this statute works.
And this is where the amicus disagrees with you, because they say there was an understanding that's pretty clear based on what happened between 1924 and 1983.
If the proposed amendment in 1983 was going to work a important substantive change like that, we would have seen it come up in the legislative history. The Mass Municipal Association sends a letter to the governor and to the legislature saying, yes, support this bill because of the procedure. It doesn't say it doesn't say if you do this, we've been relying on this meaning of the statute and suddenly it's going to mean something else tomorrow. It just says we want the new procedure, go ahead and approve it. Your Honor, I'm well over time, so if there are no
Let me just
questions.
check.
Yeah, So the one issue on the prescription for the southern portion that I was interested in your brief comment on would be your opponent's view that the judge engaged in a presumption that applies to private prescriptions but not to public prescription. What do you say to that? I can't find the language. I know it was pointed out to us. I'm just not finding it when I'm looking here in the opinion. But
Yes, Your Honor. So the land court applied and recited the exact same standard that the abutters are saying applies here. It cited to the same cases in Baluchian and Boxborough. It said, I need to make a finding that the use looks more like public use under a claim of right than like private permissive use. And then it made that finding. There was an explanatory parenthetical to a site saying evidence of permission would rebut a presumption, but he wasn't applying that to a presumption. He was saying there's no.
There's a phrase in his text that they have pointed out and cited that suggests that he was engaged in some sort of presumption. But you know what? I can find it and I'll figure it out.
So, Your Honor, if you'll give me, I have the language in front of me. It's at the bottom of page 56 of this decision.
Exactly where I was looking.
It's
which have not been rebutted.
establishes.
But that has to do with the limestone workers.
And, Your Honor, the important word there is establishes the elements of prescriptive use. Not, I'm assuming it was prescriptive use and they haven't rebutted it. The evidence shows it was prescriptive use and there's no evidence on the other side that undermines my conclusion.
Thank you.
And we will leave it there.
Thank you.
The case has been submitted. Counsel, excellent briefs, excellent arguments. That will end today's session in this courtroom. I'd like to thank the court staff, in particular our court officer, Ms. Montgomery, and our timekeeper. We will stand in recess. Thank you.
All right.